I had two interesting new client conversations today, and they were both about post-matrimonial enforcement situations. And so it made me think that this is an excellent topic for a video. So that's the genesis of today's video. In New York, we generally have situations where people enter into separation agreements and stipulations of settlement and then get divorced pursuant to a judgment of divorce. And there are many situations where after the parties get divorced, sometimes a year later, sometimes 5 or 10 years later, and both of these situations were about 5 years later, where one party believes that the other party has not followed the terms of the separation agreement and is therefore in violation of the court order, the judgment of divorce. So I wanted to talk a little bit about what goes into an enforcement application and what an attorney does as part of that process. And when I say enforcement application, when we get this kind of situation in, there are usually a variety of issues, such as non-payment of child support, issues with regard to unreimbursed health expenses, a concern about who's going to pay counsel fees for the application. And another aspect of the situation is that with many of these applications, once you put the bits and pieces together, the amount of arrears can be thousands or tens of thousands of dollars. But is it worth it from the perspective of attorney's fees to go into court with one of these applications? And so as I sat listening to the two different stories, one story was from a client who is maybe bringing an application, and the other story was a client who has been served with an order to show cause and is being requested to pay arrears and deal with other aspects of the agreement and judgment of divorce. So as an attorney, I immediately want to see the separation agreement, stipulation of settlement, and the judgment of divorce to see what the issues are in the case. And the clients will typically put together a summary of what's involved in terms of money that has not been paid, what other issues that they might want to address, such as seeing a life insurance policy that the other party is required to maintain. So there are a variety of issues that come up with post-matrimonial enforcement. Counsel fees is often one of them, and there is a specific statute in the domestic relations law in New York that deals with counsel fees where one party has violated the terms of the party's agreement and the judgment of divorce. And often in many agreements, there's a specific provision that talks about default and counsel fees. So there are a variety of ways of proceeding, including a letter to the defaulting party summarizing the issues. I would encourage that people attempt to resolve these issues out of court, possibly by going to a mediator, or just going through a process of exchanging information and having attorneys discuss what the issues are. So there's more to it, as there always is. And if you have questions, please contact me. My name is Ken Novenstern. I'm a partner in the law firm of Fredman, Baken, and Novenstern, LLP. We have offices in White Plains and Mount Kisco, New York. And my email address is knovenstern@fbndivorcelaw.com. I look forward to talking with you.